Hello learners, welcome back to our political science e-learning portal, and today in this video we are going to deal with the 7 core provisions of the political philosophy of our Indian Constitution. These core provisions are individual freedom, social justice, respect for diversity and minority rights, secularism, universal franchise, federalism, and national identity. Let us begin with our first core provision, that is individual freedom. Now, children, the first point to note about the Constitution of our India is its commitment to individual freedom. Now, with this individual freedom, we refer to freedoms like the freedom of thought, expression, belief and worship, etc. And all these freedoms have been mentioned in the preamble of our country. Now, we must understand that this commitment towards individual freedom did not emerge all of a sudden. It was in fact the result of the continuous intellectual and political activity that was going on from the ages. Like for example, you can take that this particular individual freedom thought began somewhere in the beginning of the 19th century itself, where Raja Ram Mohan Roy totally protested against the curtailment of freedom of press by the British colonial state. Now, what does it mean? Actually, during the British time, the Britishers had imposed the Vernacular Press Act, according to which the Indians were not permitted to publish any kind of their writings until and unless it's not approved by the British authorities or maybe by the British editorials, as well as they were not permitted to publish anything in the vernacular language. Now, here at this particular point, Raja Ram Mohan Roy argued that a state responsive to the needs of individuals must provide them the means by which their needs are communicated. Now, by this he means that it is a responsibility of the ruling authority of a particular place that it should give this freedom of thought and expression to every individual as their birthright. They should not only be permitted to express themselves publicly through their writings, but a kind of a thought processing arena or what you call as platform should also be provided to them, where they not only write and express, but in fact they are even able to have a kind of hot discussions on certain issues that were very much relevant during that particular time. And this is what we actually are demanding even today, and we are lucky that now at this particular stage we have been provided this individual freedom by the government, and that is why we find that media is not under anybody's subjugation. Media is totally independent, it is totally free, it is not under anybody's authority or anybody's control. You are free to express yourself in the form of writings, in the form of debates, in the form of dialogues, and whatever. See, it is therefore not surprising that the freedom of expression is an integral part of the Indian Constitution. So, is a freedom from arbitrary arrest. Now, what do we mean by the term arbitrary arrest? Actually, it means the forced arrest without any kind of evidences. If you remember the Rowlatt Act that was passed by the Britishers, according to that act, without any kind of evidence, without any kind of reasons, they were not only capturing the Indians, but they were treating them very badly within the bars, and they were not permitting them to go and apply for any kind of justice in the court. Now, this need to be stopped. This need to have a particular end whenever we are talking about individual freedom. And we have seen, and our history has been an evidence how our own freedom fighters have revolted against this Rowlatt Act. Okay, so in that case, how this started with the Rowlatt Act Satyagraha under the supervision of Gandhiji, and how they tried to oppose it. Till today, it is the freedom of every individual to know the reason why he or she has been arrested. And not only this, they even have the freedom to, you can say, approach the court within the 24 hours of their arrest. It is mandatory to take the arrested person or to present the arrested person before the magistrate within 24 hours. This is his individual freedom, this is his individual right, and nobody can take it. So we can conclude that the Indian constitution has a pretty strong liberal character, which provides freedom to all the individuals who are the citizen of the country. Even in the chapter of fundamental rights, we have already seen that how the constitution values the individual freedom. You can even recall that over 40 years before we had already adopted our constitution, every single revolution, every scheme, every bill, as well as the report of the Indian National Congress was totally focusing about the individual rights. That is why, when it was a time to form or what you call frame the Indian Constitution, the main thing which they totally focus as a core provision for our Indian Constitution was individual freedom. So I hope you understood what do we mean by the term individual freedom. Now, when we talk about social justice, we actually are talking about liberalism. And when we say that Indian constitution is liberal, we actually do not mean that it is liberal only in the classical Western sense, where all the privileges of the rights of the individuals were given on the demands of social justice and community values. In fact, the liberalism of the Indian constitution differs from this version in two ways. So it's very essential for us to understand that some special constitutional measures were required in order to advance the interests of the socially backward groups in our country. Therefore, when the constitution makers were drafting the constitution of our country, they decided that they must provide a number of some special measures to protect the interests of the scheduled castes as well as scheduled tribes, like giving them some kind of reservation of seats in legislature, even providing them some reservation while they are seeking admission in some great institutions of the country, as well as also giving them some kind of reservations in public sector jobs so that they can start getting some kind of platform where they can grow themselves and break the shackles of the kind of a tyrannical rule which they have been facing or undergoing, not from the outsiders but even from the people of their own country, in the form of social evils like untouchability. Now, when we are talking about Indian liberalism, we can say that it basically has two streams. The first stream began with Raja Ram Mohan Roy, where he emphasized on individual rights, particularly the right of women. And if you remember in your junior classes, you have studied that it was Raja Ram Mohan Roy only who totally was against the, you can say, the social dogmas of sati system that was being practiced during the ancient time by our own society people. And he tried to prove it that there is no word like sati that has been mentioned in any kind of you can say the historical texts or even the mythological texts. Nothing, there was no mention of sati system, and that is why he found the sati system to be somewhat not having any kind of practicality, and so he tried to work in order to remove this particular system, and finally with the help of the Britishers he abolished sati in our country. Then the second stream which we can talk about was the stream which included the thinkers like K.C. Sen, Justice Ranade, as well as Swami Vivekananda. Well, these thinkers introduced the spirit of social justice within orthodox Hinduism, and they tried to prove that any kind of you can say the discrimination on the basis of upper caste as well as lower caste within Hindu religion only, or maybe the practice of you can say the child marriage or anti-widow remarriages, were totally some kind of practices that had no worth, no you can say background in our society. And so we must try to do away with all these social dogmas that were present in the orthodox Hinduism. So we can say that our constitution makers really worked a lot in order to establish social justice and liberalism, and these constitutional makers were totally working in parallel to the famous thinkers who really worked hard in order to bring, you can say, change in the society and set up the social justice. Now, next is secularism. Children, we need to understand the fact that the term secular was not initially mentioned in the Indian constitution yet. The Indian constitution has always been secular in its nature. The mainstream Western conception of secularism means mutual exclusion of state and religion in order to protect the values such as individual freedom and citizenship rights of the individuals. Now, you must be thinking that when this secularism initially was not a part of Indian constitution, then how and when was it merged and made the most vital or the important part of our constitution? Actually, it was put in the preamble of the Constitution through the 42nd Amendment simply to reaffirm the faith of the nation in making the national politics stay above petty religious consideration, as well as showing due respect to all the religion. The term secular means that the state has no religion of its own. The state is neither religious nor anti-religious. The state observes complete neutrality in religious matters, and India, therefore, is considered to be a secular state. Because in Indian constitution from articles 25 to 28, the right to freedom of religion has been granted to all the persons residing in any part of the country. They have the freedom to choose any religion of their choice, as well as to preach and practice any religion irrespective of whichever religion they have taken birth in. Even the 45th Amendment lays down the fact that the term secular means that all religions carry equal respect and recognition from the state, that is the government. And therefore secularism has been adopted as an integral part of a constitution in order to safeguard the freedom of individuals irrespective of whatever religion they have taken birth in. Now, we cannot deny the fact that our constitution makers adopted secularism from the constitution of the Western countries, mainly from US. But we could not adopt secularism in its pure form. And the reason behind this was that our country is a multi-religious country where there are not one or two communities, but there are multiple of communities. And that is why our constitution makers decided that they can include secularism as one of the core value of our constitution only when it has been modified as per the needs of our country. And that is why they tried to modify it into two ways. The first is by providing the rights of the religious groups. Now, what does it mean? Actually, when our constitution makers were studying secularism, they recognized that the inter-community equality is as essential as the equality between different individuals. Because no matter if we provide equality to the individuals, but if the communities do not have the sense of equality between them or among them, then in that case, directly or indirectly, the individuals won't consider themselves to be free as well as equal. Because every person's freedom and the sense of self-respect is in one way or the other, what you call as directly or indirectly, dependent upon the status of his or her own community. If one community is dominated by the another, as in the case of what we call as inter-community domination, in that case also the community that has been dominated, the members of that community feel as if they are not free, they are not equal. And that is why if we want to provide equality to all the individuals, first what we need to cater to is to establish equality between different communities. And then only every member of all the communities will be able to walk with dignity, self respect, and have freedom, have the sense of freedom. And in that way only we will be able to attain equality in its pure form. Otherwise we can just say that equality is there, but until unless there is no equality between the communities, individual equality would only be a mere dream and not the reality. Now, the next change that was brought over here was the introduction of the state's power of intervention. Now, what do we actually mean by this? We know that according to secularism, the state doesn't interfere into any kind of religious matters, nor does it have any religion of its own. But in a country like India, where we have multiple of religions, there if we expect the state not to interfere into any of the religious matters, then it really becomes difficult for the state to sort out all the religious issues. Because in our country over the years we have seen that there were certain social dogmas, or what you call as the social evils, like that of untouchability, which have been depriving the individuals of the most basic dignity as well as the self respect. As a result, until and unless the government or the state does not interfere in order to remove this particular social dogma, we cannot expect the 100% equality, or you can say the freedom given to all the religions in a particular country. That is why our constitution makers provided this power of intervention to the state, by which a state may help, or you can say in any particular religious community, to attain the freedom and equality for all the citizens of their religion, for all the followers of their religion. And in this manner, secularism can be set up in a country in a purest form in 100% manner.